All right, Scott, thanks. The group hoping to get abortion on the ballot in Arkansas this November officially filing a legal challenge today after the Arkansas Secretary of State disqualified that effort last week. 5 News reporter Kayla Davis joining us now in the studio to break down where things stand right now. Kayla?
That's right, Darren. Today, Arkansas for Limited Government, or AFLG, filed a lawsuit alleging the Secretary of State's rejection of their proposed amendment was unlawful after it was tossed out earlier this month for failure to submit required documents regarding paid canvassers. Well, Jenny Diaz with AFLG claims those documents were submitted and the office failed to perform an initial count of all signatures submitted. On July 10th, Secretary of State John Thurston sent a statement to AFLG stating they failed to submit a statement identifying paid canvassers by name and a signed statement that they gave a copy of the most recent Secretary of State's handbook and explained all rules before allowing them to collect signatures. Thurston's letter goes on to state that he cannot count the paid canvassers' collected signatures, which amounts to be about 14,143. But Jenny Diaz with AFLG claims they have been in compliance with the office throughout the entire process.
He was saying, you're missing this sheet of paperwork that's typically given to us, even though it's not required by statute. And because of that, we're disqualifying you. And that, is actually unlawful. So that has really informed how we have proceeded since receiving that letter last week.
AFLG has since filed a lawsuit to the Supreme Court to force Thurston to count those signatures because they claim they have submitted those statements before the July 5th deadline.
The Arkansas Code requires that we submit to the state a sponsor statement affirming that we have done all of these required things by the state in order to have our paid canvassers certified to collect signatures. We did that 17 times. We submitted those affidavits to the state.
Despite the office not counting, Diaz says they still have volunteers out collecting signatures to make up for invalid signatures during the 30-day grace period.
They are, effectively putting that clock in motion for us where time is running out, which is, again, an obstruction of the people's process, in addition to their failure to count these signatures, which is really unfortunate.
Executive Director of the Family Council Action Committee, Jerry Cox, says this is not surprising for their group.
You just can't fail to obey the law and somehow expect then to be able to qualify for the ballot. And so I don't believe they have much of a path forward.
Cox says they're ready to push back should the lawsuit go through and the counted signatures be approved.
In the unlikely event that somehow they do end up checking the signatures and this does move forward and it does get certified for the ballot, then the options open for us would be to do a ballot title challenge, which says the text of the measure is misleading, the ballot title is misleading, or to challenge the signatures themselves.
And AFLG says they're just as passionate about continuing to fight for the amendment. AFLG says they've asked for an expedited process as the election is only months away. We also reached out to the Secretary of State's office today, and they say they have no official statement on the lawsuit at this time. Kayla Davis, 5 News.